Oh, sorry. Please finish. I was just going to ask, is your formalistic test just a way of trying to deal with our precedent, or are you rooting that in the Constitution itself? Because you do have a problem with explaining why these procedural limitations are okay, but substantive limitations are not.
Well, Your Honor, we certainly have tried to craft an argument that is consistent with all of the court's precedents, but we think that there are good reasons why there would be a substantive limitation, even if not a procedural limitation. We can see this in James Madison's remarks. I would refer the court to the third volume of Eliot's Debates, page 367, where James Madison laments partisan gerrymandering, and he singles out one state, South Carolina, for opprobrium for their partisan gerrymander. And their partisan gerrymander was found right in the state constitution. And that's the rule that my friends on the other side are advocating for. They're saying you can have a partisan gerrymander, but you have to put it in the state constitution.
So that's not so much your argument then, this procedural substantive distinction is not so much a matter of the text, but it's you're pulling some things from the history and saying, like James Madison's comment supports this procedural substantive line.
Well, we ground it in precedent, Your Honor, and text, and structure, and history. So I'll take those one at a time, if I may.
Sure.
So the precedent would be Smiley on the one hand seems to suggest that procedural limitations can be circumscribed on the legislature, and Palm Beach County, as we read it, teaches that substantive limits cannot be placed on a state legislature. So that's the precedent. In terms of the text, I think all of us agree, Your Honor, that it's a lawmaking function. And so, and the text shows that where it says prescribe regulations, this is the lawmaking function. And so it makes sense the founders structurally would have said, okay, there's a pre-existing entity, the state legislature, and we're going to have that be bound by its procedures, but we're going to have federal substantive limitations. And you can see this with state courts.